Johan Namkung, and I represent Ms. Dara Davis. Today, myself and my counsel ask that you reverse the reward and opinion of the Industrial Commission and find that Ms. Davis's injury did arise out of her employment for the following reasons. First, Ms. Dara Davis conferred an appreciable benefit to her employer, establishing a causal connection between her injury and her employment. Second, injuries are compensable even though they benefit third parties or the actor, as long as an appreciable benefit is conferred to the employer. The facts of this case are as follows. In May of 2008, Ms. Dara Davis began working for the Raleigh Rage as a cheerleader. She would go to games and excite crowds for the benefit of the Rage so that they could increase their ticket sales and their sale of merchandise. In December of 2009, Mr. Winborn, the owner of the Raleigh Rage, held a meeting to highlight the importance of the Holiday Health Happening event, which was held by HealthCares, which is the biggest healthcare conglomerate in the region. Mr. Winborn, while speaking to the cheerleaders...
Counselor, you can move on from the facts here. I think we're all familiar. If you wouldn't mind getting into your argument.
Sure, Your Honor. First, Ms. Dara Davis's injury arose out of her employment because there was a causal connection between her work and her injury. This causal connection was established by the appreciable benefit that she conferred to her employer. The case I'd like to use for this argument, Your Honors, is Guest versus Ironworks Company. In Guest versus Ironworks Company, the employer had sent Mr. Guest and another employee to go fix some flat tires. And once the employees got to the place they needed to fix the flat tires, they asked a service station to use their air. And while they were using the air, a worker of the service company, of the service station, had asked Mr. Guest and the employee to help move a stranded vehicle. And so the employee and Mr. Guest went to the stranded vehicle and were helping push the car when another vehicle struck Mr. Guest, resulting in his death. In that case, a court concluded that Mr. Guest was acting when his injury arose from his employment because there was a causal connection established. The court said that the appreciable benefit that Mr. Guest had on his employer was that of filling the air for the tires. And in order to fill the air for the tires, which would be the appreciable benefit, he reasonably was expected to help push the car so that he could use the free air for his employer. Like the employees in the Guest case, Ms. Dara Davis went to the Holiday Health Happening event. She went there and she met with other people who were at the event. She posed for pictures, she signed autographs, and that established a causal connection, and she appreciably benefited her employer, Mr. Winborn, by doing those things. And the question in this case is whether her performing the stunt on the trampoline also appreciably benefited Mr. Winborn at the Raleigh Rage and established this causal connection so that her injury would be compensable.
Counselor, you said that the pushing of the car was in some way necessary for the benefit gained by the employer. I'm wondering, how is that at all analogous to Ms. Davis's case here? What would be her pushing of the car, per se?
Well, her pushing of the car originally started, Your Honor, with signing autographs and posing for pictures. But then when Ms. Chavez, who is the head of the physical therapy department for HealthCares, asked her to perform some tricks to excite the crowd as the numbers of the crowds were beginning to dwindle. This was the point where she continued that appreciable benefit on her employer, because at that meeting, as I had mentioned previously in the facts, Miss Dara Davis had been specifically told by the Raleigh Rage owner, Mr. Winborn, about the naming rights estimated value at $43 million that he was trying to get from HealthCares. So by exciting the crowd, which was something that she was used to doing at football games, and performing stunts, which also like a cheerleader she was used to doing for the Raleigh Rage, this established the causal connection. And
Counselor, is performing stunts something that she regularly did at publicity events?
Your Honor, well actually, there was no specific mention in the facts found by the Industrial Commission that she performed stunts at these publicity events, but we can reasonably infer that performing stunts is an expectation of these cheerleaders to do at these publicity events.
Could we also reasonably infer that she performed that stunt which caused her injury because she wanted to impress Dr. Chavez and she was looking for employment from Dr. Chavez?
Why, yes, Your Honor, I would agree with you. There may have been some other motivation to impress Dr. Chavez. As you know, that Miss Dara Davis has a background in physical therapy. However, that sort of brings me to my second point, Your Honor, that benefits to third parties or even the actor or the claimant do not prohibit or stop a claimant from compensation as long as that appreciable benefit to the employer exists. And as I had mentioned previously, the appreciable benefit to the employer, the Raleigh Rage in this situation, was that increased benefit of publicity for the crowds at the event and for Ms. Chavez, who is an employee of HealthCares. So the next case that I'd like to compare this case to is Culpeper versus Sapphire Valley, in which a cocktail waitress who worked at a resort was on the clock and working, and her duties was to make the customers feel comfortable and, like Miss Dara Davis, sort of had a publicity and relationship role with the customers at the resort. And on her way to work, this cocktail waitress saw a resort customer stranded on the side of the road and decided to help that customer when she incurred her injury.
Counselor, are you aware of any policy that Sapphire Valley Country Club had that would cause Ms. Culpeper to perform this task?
Well, yes, Your Honor. I believe the opinion stated specifically that Ms. Culpeper had warded off attempts at that particular customer on the side of the road, but the only reason that she had stopped was because she reasonably expected that her employer would have wanted her to for the furtherance of that resort's business.
And how do you rectify that Ms. Davis did not have a similar policy?
Well, Your Honor, Ms. Davis's job, much like that cocktail waitress, was not necessarily strict and embedded in stone. Her image was to portray the Raleigh Rage football team to increase merchandise and ticket sales. And although it was not specified that she had to do stunts or her job duties were not explicitly specified, I think it would be reasonable to infer that it would include performing stunts as a cheerleader. So the second point I'd like to bring up, Your Honors, is that, as I had mentioned previously, that a claim is compensable when a third party is benefited or even the claimant is benefited, so long as the employer is appreciably benefited. And I'd like to offer a case that provides a stark contrast in which the court found that the employee was only benefited for himself or a third party, and that there was no appreciable benefit to the employer. And I realize that my time is up, Your Honors. If I could have a minute to conclude.
Please.
Quick session to conclude. For the reasons stated above, I ask that you reverse the findings of the industrial commission and find that Ms. Davis's injuries did arise from her employment.
It's like if you ask